Francesca Capone. I'm Associate Professor of International Law at the Scuola Superiore Sant'Anna in Pisa, and I'm delighted to actually introduce this book launch. So if you agree with my plan, I will briefly introduce our two guests, Professor William Schabas, of course, and Dr. Stefano Marinelli. And then I will give you the floor for your presentations, and afterwards we will have a Q&A session open also to the other participants that are starting to show up online. Okay? I will start with the introduction of our distinguished guest, and I am absolutely delighted to introduce them. So Dr. Stefano Marinelli holds a PhD in international law at the Middlesex University of London and an LLM at the Geneva Academy of International Humanitarian Law and Human Rights. He is a member of Agency for Peacebuilding, where he conducts monitoring and evaluation activities for transitional justice projects. He is also a lecturer at the Master of Conflict Management and Humanitarian Action at the University of Siena, and is currently serving as a researcher at the Istituto degli Innocenti of Florence, very close to my place, so we are actually nearby. Our second guest is Professor William Schabas, who definitely does not need an introduction, but just for the sake of keeping up with the appearances, I will also introduce him, and he is, for me at least, one of the most authoritative figures in the realm of both international human rights law and international criminal law. And I must say that as a student, I actually developed a passion towards ICL in particular, thanks to the contribution of authors like Professor Schabas and like the late Antonio Cassese. So I'm particularly thrilled to actually have the honor of welcoming him to this webinar, also on behalf of my colleagues, and in particular Professor Martinico. As you know, Professor Schabas is currently Professor of International Law at Middlesex University in London, and therefore he was also the supervisor of Dr. Marinelli while he was producing this excellent work. He's also Professor of International Human Rights and at Leiden University, Emeritus Professor of Human Rights Law at the National University of Ireland, Galway, and Honorary Chairman of the Irish Centre for Human Rights, and indeed also invited visiting scholar at the Paris School of International Affairs. Professor Schabas from 2002 to 2004 served as one of the 3 international members of the Sierra Leone Truth and Reconciliation Commission, which is still one of the most studied and researched TRC to these days. In 2014, he was appointed as the chairman of the UN Commission of Inquiry into the Gaza War, and he has, as we all know, worked as a consultant on a number of different topics, in particular on capital punishment for the United Nations Office of Drugs and Crimes, and he drafted several reports of the UN Secretary General on the status of death penalty. So, besides introducing our guest, I am also very excited to briefly present the book that we are about to launch with this seminar, and that has been authored by Dr. Marinelli. And in fact, he was able to transform his PhD dissertation into a very excellent monograph. The title, as you probably know already, is The International Criminal Court and the Responsibility to Protect. And this book is extremely important because it fills a very significant gap that existed in the literature by providing a much needed parallelism between the first permanent World Criminal Court and the Responsibility to Protect doctrine. As the two institutions actually are able to influence, as Dr. Marinelli's book is capable of showing very clearly, fundamental elements of international law that can really contribute to its evolution, not just from the perspective of ICL or from the perspective of the use of force. The book combines a very strong theoretical foundation with more practical aspects. In particular, Dr. Marinelli has carried out a very thorough analysis of 3 case studies, which are Darfur, Libya, and Syria. And we can say that the ultimate goal of the research that Dr. Marinelli has conducted is to actually show the full potential of these two institutions in order to contribute to conciliate the notion of sovereignty, which, as we know, represents one of the main grounds of modern international law, and at the same time, it also represents one of its most controversial tenets, with the accountability for the perpetrators of international crimes, and obviously the need to protect in an effective way the population from mass violence. So with this brief introduction, I will just stop and I will give the floor first to Dr. Marinelli, who will provide us with a more detailed account of the key aspects and issues that have been raised and addressed in this very interesting and excellent book. And then immediately after Dr. Marinelli's presentation, I will give the floor to Professor William Schabas, that will act as the discussant for this book launch. Thank you so much. Stefano, you have the floor.
Thank you very much for the introduction to Professor Capone, and also to the entire team of the Sant'Anna Legal Studies for organizing this launch. I will try now to present how I developed my book, my research. As Professor Capone was saying, it grew out of my doctoral thesis, and it tried to create this unusual parallelism between an international tribunal, the International Criminal Court, and an international law doctrine, the responsibility to protect. I will present the most interesting points and findings, also in the light of the recent last week's developments in the practice of the International Criminal Court. First of all, the research is relevant as far as the doctrine, the court and the doctrine share a remarkable number of aspects in common. They have a parallel history, both having been developed in the last 2 decades, a common cultural background, which privileges individual dignity over state sovereignty that Professor Capone mentioned, and they both pursue the aim of preventing and putting an end to mass violence and international crimes. In particular, they share the purpose and the subject matter jurisdiction of similar international crimes, despite some differences that I will present. The connections between the two have been highlighted by UN bodies, by the ICC various prosecutors, UN Secretary Generals, judges of the court, and many scholars. But despite this clear relationship between the two, and despite their parallel impacts and on the foundational norms of international law, this parallelism remained largely overlooked. So my book covered the interplay of the two institutions in practice, with opposite case studies of Libya and Syria, also mentioning Darfur, and examined the theoretical value for the evolution of the discipline as they influence fundamental elements of international law, like the prohibition on the use of force as state sovereignty. So first of all, I dealt with the theory, the theoretical common cultural origin that can be defined as liberal cosmopolitanism. And I found this particularly interesting because the idea, the notion of liberalism and cosmopolitanism has very different connotations in the field, in the scholarship. Liberalism and cosmopolitanism can be conceived as the only decent way to deal with fundamental values like human dignity and with international law in general. But on the other hand, there are scholars that consider liberalism and cosmopolitanism, analyzing the practice of how these principles were implemented in the last decades, as synonyms of imperialism or ways to justify the use of force, let's say, or military interventions. Indeed, liberal cosmopolitanism has been criticized on various grounds. It focuses, first of all, on individual human beings, rather than on collective entities, like on societies. and in so doing, it disregards dynamics of power in a community. It doesn't deal with politics. It depoliticizes issues. It also neglects the diversity of local specificities, and in so doing, it disregards inequalities, both at the state level between major powers and less powerful states, and in the international community, and inside also each state. Secondly, international liberal cosmopolitanism replaces state power and state sovereignty in some on some levels, on some grounds, and this poses problems of legitimacy and democracy. Third, it overlooks the structural causes of violent events it tries to prevent. So when it deals with the mass violence, it focuses on individual victims and individual perpetrators working in the conflict, but without addressing the root causes and the reasons why the mass violent events were born and developed. Finally, the idea of liberal cosmopolitanism promoting universal value is realistic, as any institution claiming to represent all of humanity and to pursue universal values in good faith is unavoidably subject to biases and partiality. However, this happens in practice, but it is interesting to see what is liberal cosmopolitanism in theory, being a sort of philosophy, and looking at the original authors of this field of study, this school of thought, let's say, like Immanuel Kant or Hans Kelsen, who wrote For Perpetual Peace or Peace Through Law, we see that this was clearly a pacifist philosophy. And so there is an interesting gap between theory and practice. Something similar somehow happened with the definition of atrocity crimes, which is another important concept in the relation between the International Criminal Court and the responsibility to protect, that has a strong gap between theory and practice. Indeed, the expression was introduced to consolidate the relevant areas of international criminal law, but and to simplify also the field. Like there are a number of international crimes, like war crimes, like crimes against humanity, genocide, that have some differences and that somehow complicate the work on them somehow. So the idea of unifying the core international crimes under a different term had the purpose to simplify the discipline. But the definition of atrocity crimes demonstrated to be inconsistent in its meaning, as it includes, for example, ethnic cleansing, a crime that is not defined in international criminal law and does not fall within the jurisdiction of the International Criminal Court. And most of all, it doesn't include the crime of aggression, which is included in the Rome Statute. But most of all, it has been considered the supreme crime since the beginning of the development of international criminal law, like at the Nuremberg trial, for example. But it gradually, the crime of aggression gradually disappeared from the definition of atrocity crimes. And the exclusion of the supreme crime from the definition of atrocity crimes seems to suggest that indeed the use of this expression has a rhetorical purpose, rather a good faith purpose of simplifying the discipline, which can promote also interventions rather than the progressive development of the discipline. Then I focused more in practice on the case study of Darfur and Libya, which are the Security Council referrals to the International Criminal Court. So the relationship between the United Nations Security Council and the International Criminal Court can be examined under these two cases, and these two resolutions, these two referrals, already contain interesting points about anticipate somehow some issues concerning their implementation. For the first time, the Resolution 1970 of 2011 expressly mentioned the responsibility to protect as a ground to trigger the court's jurisdiction. So this unusual relationship between an international tribunal and an international law doctrine was realized, was implemented in practice in the Libyan resolution. But the action of the court in Libya, similarly to what happened in Darfur, did not achieve the expected results, both in terms of legal and political issues. The two referrals, as I was saying, highlight controversial provisions, such as the selective exclusion of certain categories of people from the jurisdiction of the court, the lack of special funding from the UN from the specific situations referred by the Security Council, and the ambiguous obligations imposed on non-state parties. So initially, there was some enthusiasm surrounding the Darfur referral in 2005, and even the Libya referral in 2011, thinking that the Security Council could implement both the responsibility to protect and activate the International Criminal Court, so to reach the protections of civilian populations and justice and international justice, but overall awareness has increased of the undesirable effects of the Council influence over the court. We must say that given the recent developments that concern directly the head of state of one of the 5 permanent members of the Security Council, it is now extremely unlikely that there will be further Security Council referrals in the next future. Then the third chapter deals with another case study of Syria, exploring the relationship between the Security Council and the responsibility to protect. We see that the Council makes a very partial application of the doctrine, and that after Libya, the Council approach to the responsibility to protect changed completely. Indeed, after the Council actions in Libya, which resulted in a regime change, in a full military intervention of NATO, and in the regime change in the state of Libya, Russia and China understood that the use of the court and of the doctrine by the Security Council was no longer acceptable, and vetoed proposal to refer the Syria situation. As a result, there were debates also in scholarship about possible avenues to bypass the veto power of the 5 permanent members of the Security Council when a resolution would protect population from grave international crimes. So there were a number of analyses of initiatives, from the old Uniting for Peace to the most recent Brazilian initiative, Responsibility While Protecting. In any case, the analysis of all these initiatives demonstrate that there are no lawful alternatives to Security Council authorizations of the use of force. The important point, however, is also to argue, to remember, to consider that bypassing the veto power, thus obtaining a higher number of Security Council resolutions and interventions, is not necessarily a desirable outcome from the protection of populations from mass violence. Then I went ahead investigating how the International Criminal Court is expected to prevent international crimes by prosecuting those responsible. So the court's capability to protect. And here, the theory of deterrence is a key concept for the court's preventing function. And there is a lot of scholarship on the theory of deterrence in international law. And despite optimistic findings by some researchers, we see that there is no clear evidence that the court or international criminal justice in general can deter crimes. Indeed, violent criminals are discouraged not so much by the gravity of the penalty as by the likelihood of apprehension. And it seems hard to say that an international court that was capable of recording less than 10 convictions in a space of nearly 2 decades can constitute a realistic threat to potential offenders. In practice, we saw that the court has been maintaining deterrence among the primary purposes of these sentences, but deterrence has not influenced the prosecutorial strategy so far. To promote deterrence, in sum, the court must be perceived as legitimate and effective. Indeed, the achievement of a credible and functioning international tribunal would have a stronger impact on perpetrators or potential perpetrators than any specific punishment. Finally, I, in the 5th and 6th chapter, analyze the impact of the doctrine on the prohibition on the use of force and on state sovereignty. Concerning the prohibition on the use of force, I argue that the court contributed to the jus contra bellum, to strengthening the prohibition by criminalizing acts of aggression. But the difficulties to activate the court's jurisdiction over aggression that were evident also in the situation of Ukraine are making any prosecution for the crime of aggression unlikely. With reference to the responsibility to protect, the doctrine has contributed to strengthening the prohibition on the use of force, and this is a sort of paradox because the doctrine was born as a way to introduce a new exception to the prohibition of the use of force, but discussing the doctrine, states have had the opportunity to confirm the consistent opinio juris in the international community against exceptions to the prohibition on the use of force based on humanitarian claim. As a result, the impact of the doctrine would be in line with the criminalization of aggression by the Rome Statute, as they both reinforced the prohibition on the use of force. Finally, concerning the state sovereignty, the regional culture, liberal cosmopolitanism of both institutions clearly favors individual dignity over the sovereignty of nation states, but a deeper analysis shows a more complex dynamic. Indeed, the reading of the school of thought criticizing the global trend opposing sovereignty challenges the conflicting dynamic between sovereignty and human dignity. Sovereignty indeed can play a role, has a role in protecting states and consequently the human rights of their population against interference from major powers and also transnational non-democratic institutions. The complementarity approach of the International Criminal Court, which is based on a statute binding in principle, with some exceptions only the state parties, does not constitute a threat to sovereignty if compared to previous international tribunals that replaced the primary jurisdiction of the territorial states without the latter's consent, for example, the ad hoc tribunals established by the Security Council. On the contrary, the practice of the court shows a lack of independence, as it must rely on the cooperation of states or of the Security Council to implement its mandate. Concerning the responsibility to protect, the approach to sovereignty, as I was saying, it's a paradox. It made a sort of U-turn between the initial idea of sovereignty as responsibility, allowing the international community to intervene in case of failure of the territorial state, and all the subsequent formulations until the Secretary General's reports and all the plenary discussions within the General Assembly that ultimately portrayed the doctrine as an ally of sovereignty that reinforced the sovereignty. So, to conclude, the book reveals that the interplay between the International Criminal Court and the responsibility to protect affects crucial areas of international law: the protection of human rights, the prevention of core crimes, the effectiveness of the Security Council, the role of international criminal justice in protecting populations, the prohibition of the use of force, and the principle of state sovereignty. The analysis of case studies in practice suggests that coordinated action between the two is neither feasible nor desirable. On the one hand, the responsibility to protect acquired and introduced a new language in the United Nations and the protection of civilians, but it has not introduced any new legal obligation. The doctrine has introduced a new jargon and a new focus on humanitarian issues in the political and diplomatical debate. On the other hand, the court struggles with selectivity, enforcement, with fulfilling its statutory mandate while resisting political pressure and suffering a lack of support. The problems, these two problems experienced by the two institutions are related insofar as they concern efforts to become effective and gain independence from the political power, but the paths to the solutions for these problems are not interconnectable. At the same time, the doctrine and the court are contributing to the evolution of international law, like the principle I have mentioned, through subtle and complex dynamics. Their mandate compels them to respond promptly to events of mass violence, but their failures result in protected violence and in humanitarian crisis, which undermines the high expectations of their performance. This perception also affects research on the doctrine and the court. There is a lot of scholarship concerning the failure of also the incoming death of the court and the doctrine. However, a tight focus on biased implementation and ineffective outcomes hides deeper changes that the doctrine and the court might promote in international law. The affirmation of the values of accountability and responsibility while reinforcing the prohibition on using force is a permanent result that may protect possible outcomes of future misuses of the doctrine or erroneous decision of the court's organs. So I try to show the potential of the two institutions to conciliate the principle of sovereignty with accountability for perpetrators of international crimes and the protection of populations from mass violence with the prohibition of the use of force. And conciliating these values could lead towards affirmation of the main values of international law, like peace and human dignity. That's all from my part.
Many thanks, Stefano. Very interesting presentation. And also thank you for shedding light on some of the issues that I only touched upon during my introduction, but that were extremely well addressed in your book. So I will now give the floor to Professor William Schabas. Very happy to have you with us. Thank you once again for accepting our invitation. And Professor Schabas will present some comments on Stefano's book. Thank you.
Thank you very much, Francesca. And thank you for inviting me to participate in this event. Always a great pleasure, particularly to see the marvelous achievement of a student who worked under me. I have to tell you that Stefano did not require much supervision, as you can see and as you can tell from listening to his account. And really, the whole process was one of very pleasant and quite interesting discussions that we had about this notion of responsibility to protect, which, dare I say it, has marked my career now for nearly 30 years. I vividly recall still my concern in 1994 as genocide raged in Rwanda, a country that I had visited the previous year on a fact-finding mission, and watched while the massacres took place and while the Security Council stood by without taking any effective action at all for many weeks. And shortly afterwards, I attended a conference of the what was called the ACANS, the Academic Council of the United Nations System. I don't know if it still exists even, but they organized courses, and I was invited to this summer course they had in the United States. And there were two American diplomats who were there, and we debated this issue about whether there was an obligation on powerful states, on the United States in particular, and on the Security Council to take action in the case of genocide. I put forward the theory that the Genocide Convention required them to take action, and the American diplomats said, well, that was not their position. The American position was that all the Genocide Convention required them to do was to prevent genocide within the United States. Now, that view has changed, although I think from the standpoint of the United States government, the position is that is not that there's an obligation, to intervene to prevent genocide, but they would formulate it as a right. And we might all then realize that what they're really talking about is a pretext to intervene, using genocide as the justification, a theory which the Americans have developed and which has been recently picked up to some extent by the Russians, as we've all seen, as a result of the tragic events of the last year. Now, when Stefano wrote his thesis, I guess he defended it in 2021, and I wrote the preface. Thank you again, Stefano, for inviting me to do that in 2021. And there have been interesting recent developments, I think, in these areas, and I'd like to just say a few words about them. Not just over a year ago, at the very beginning of March of 2022, there was a provisional measures order issued by the International Court of Justice in the case of Ukraine versus Russia. One of the judges, Judge Bennouna from Morocco, wrote a separate opinion. I think really we can anticipate that Judge Bennouna, it's a declaration really, he called it, and he did not dissent, but he's clearly not impressed by the Ukrainian thesis that that Russia has violated the Genocide Convention by alleging falsely that genocide took place and then using it as a justification for invasion. But he also speaks, and he links this to the conversation about the responsibility to protect. He talks about, and he dates it to the intervention by the NATO countries in the Federal Republic of Yugoslavia, now Serbia, relating to events in Kosovo in 1999. And then he points out how this doctrine of the responsibility to protect developed and led to the formulation of it with the references to the international crimes in paragraphs 138 and 139 of the World Summit Outcome document adopted in September 2005. And then he goes on to say, and I quote from his opinion, sadly, in practice, the concept of responsibility to protect has been diverted from its purpose. When on 17 March 2011, the Security Council authorized member states to take action through airstrikes to protect civilian populations in Libya, NATO forces deviated from their initial mandate by favoring regime change in that country. And Stefano referred to this a few minutes ago. Judge Bennouna then finishes the paragraph with the following sentence: "This saw the end of the concept of responsibility to protect." Well, we can debate whether it's seen the end of the notion of, or the concept of, the responsibility to protect, but as Stefano pointed out, it was certainly the rationale for the veto imposed by China and Russia in 2014, when there was a Security Council draft resolution directed at referring the situation in Syria to the International Criminal Court. Some of these issues, of course, have returned in the present context of the conflict in Ukraine, and we can see this in particular in the statements by individual states that are in the file of the International Court of Justice. It's quite an extraordinary development. It's very, very unusual for states to intervene in proceedings at the International Court of Justice. They are allowed to do it. In fact, they're invited to do it by the statute of the International Court of Justice when a treaty is being interpreted to which they are a party. But in practice, I think this is a very rare occurrence for states to intervene. But there has been a campaign to promote submissions to the International Court of Justice, and I think now there are 31 or 32 of them that are on the website of the court. The court issued an order some months ago saying that the deadline would be the 15th of December of 2022 for the submission. So I suppose there won't be any more, at least for the time being. But basically, we can divide those into two, the submissions, and address two issues. The first one is the admissibility question, which is, remains to be decided by the court, and presumably will be some point, in the months or the next year or so to come. And that's it's an unusual application by Ukraine because I think it was very creative, very original by the lawyers who thought of it. I wonder if they had been thinking about this. There's not a trace of it in the literature, the suggestion that you could go to the International Court of Justice, arguing that, you had not committed genocide, asking them to declare that you had not violated the Genocide Convention. It's very unusual to do that in law. Generally, if you think you haven't violated the law, you try to stay out of court rather than to get into it. But, we're aware of the unusual nature of it. There are no real precedents for it. A few of the states who have made submissions have referred to an old case involving customs duties and France and Morocco, but it doesn't really, it's a stretched analogy with what we see today. That being said, the submissions to the court are unanimous in support of the admissibility. They're kind of cheerleading for Ukraine in terms of the admissibility of the application. That's the first part. But then most of them turn to the more substantive issue, which may or may not be addressed by the court if the case goes to the merits. And this is the relationship with R2P, with the responsibility to protect. This is whether there is some extra, outside the Charter of the United Nations, some legal justification for the use of force in order to prevent one of the crimes in the R2P paragraphs, but this is specifically directed at genocide, whether it's possible to intervene outside of the framework of the Charter. And as Stefano has pointed out, that door has been repeatedly shut. And just to digress, he discusses how it was shut at the Kampala Review Conference when the United States campaigned to have an understanding adopted associated with the amendments dealing with the crime of aggression, by which quite explicitly the use of force to prevent one of the crimes in the Rome Statute, genocide, crimes against humanity, or war crimes, would be deemed to be not a flagrant or a manifest violation of the Charter of the United Nations. And the United States wanted this quite explicitly in order to provide some sort of authorization for military intervention, even without the authorization of the United Nations Security Council. So as I say, they're the ones who've developed the case and developed the argument. It was rejected at Kampala. And Stefano describes that. He quotes some of the authorities. He doesn't quote me. I think we talked about it because I was in the room when this happened. And I remember watching it. It was a hot afternoon in Kampala on Lake Victoria, and we gathered in a crowded room. It was not a proper session. There was no It was what they call an informal. There was no interpretation. Everything went on in English, and only delegates were allowed to be in the room. So the NGOs were excluded. But I think because of my age and the color of my hair, and because I wear a suit, I could sort of slip my badge under my necktie and nobody would notice that I wasn't a delegate from a state. So I sat through this. I sat with David Sheffer, the former ambassador for war crimes. David was of the United States, but David was there in his personal capacity. And at one point he leaned over and whispered in my ear, he said, "This is not the finest hour for American diplomacy." And Stefano describes it as, I think, quoting another writer, as an unguarded moment. But finally, I'll never forget that afternoon, the United States got whipped, and none other than the Islamic Republic of Iran, which was quite humiliating. There was a great debate. The main participants were the Islamic Republic of Iran, the People's Republic of China, and the United States of America, all three of them non-party states. And they were debating what should be the understandings to go into our Rome Statute. Well, let me go back to the International Court of Justice in 2002 in these statements. As I say, there are more than 30 of them. They are not at all unanimous on this issue. During the pleadings, the oral hearing for the provisional measures last March, or at the end, was the end of February, maybe 28th or the 1st of March. I don't remember the exact date. The counsel for Ukraine did say quite explicitly, it's in the transcript of the hearing, he said, you cannot use an allegation of genocide as a justification for the use of force, which is prohibited by the charter. So quite a firm, explicit position, but not all of the states who've intervened take that position. There are some of them who do. There are several of them who have a really quite an unusual formulation where they say you have to make a good faith effort to try to engage some sort of multilateral justification for intervention. And only after you've made a good faith effort can you then take unilateral action to prevent genocide. An extraordinary formulation, and one that, of course, is completely incompatible with the Charter of the United Nations. Others took a position like what Ukraine had set forth in the oral hearing, although, you know, I would not be surprised if Ukraine nuances its position in its memorial and when the case goes to the merits. And then, quite interesting, one state was entirely silent on the subject. Need I tell you which state? The one state that has been the most outspoken in favor of the concept of intervention when as using genocide as a justification, the United States of America. The United States of America is absolutely silent on the question. We can try to understand why they would not have exploited this opportunity to take a position. Obviously, maybe they're embarrassed about the positions they've taken in the past, and maybe, and I think this is my guess is this is the real explanation, they are nervous about the fact that this case will lead to an unequivocal statement by the International Court of Justice that you cannot use force outside the framework of the Charter, even if you justify it by some sort of duty to protect or prevent, whether it's based on the doctrine of the responsibility to protect or on Article 1 of the Genocide Convention and the obligation to prevent genocide. One other state that also took a curious position is the United Kingdom. They don't talk about the responsibility to protect, but the United Kingdom seems obsessed with can we call it the ancestor of the responsibility to protect, Stefano? Humanitarian intervention. They never give up, it seems, on humanitarian intervention. And so they revive the idea of humanitarian intervention, but they too, and they're quite explicit, they say to the International Court of Justice, don't address this question. They say it's not required for you to issue your decision to rule on the merits of the Ukrainian application. Don't go there. But I think that they too are concerned about getting the same result. They have the same concern as the United States, that the court will make an unequivocal declaration. Well, I would welcome it. I think it would be a good thing for peace on the planet if we could drive a nail, more than one nail, into the coffin of the idea that states can act outside of the Charter of the United Nations. Of course, the argument against it, and this was what the proponents of the R2P, or the going back to 2001, the Canadian Commission, and those, including people in the Human Rights Committee, like Human Rights Watch, who wanted to justify in some way the use of force against Serbia, against the former Yugoslavia, in 1999, is they say, well, but if the Security Council is deadlocked, then what can you do? And of course, this is it is a dilemma in a sense, but it is one for which perhaps there is no proper answer or solution, but rather we have to make an assessment about the idea that to sacrifice the absolute prohibition on the use of force, unless the 5 huge military powers can join hands and agree upon it, is such a dangerous thing for our planet that it can never be justified by some assessment, and of course this is the other concern, of genocide. And we know, and Judge Benuna refers to it, extravagant assessments of genocide. This is clearly the case with the Russian arguments that genocide is taking place in Ukraine. But dare I say it, the Ukrainians are saying the same thing about the Russians, and they don't have a stronger case in terms of genocide, although of course they have a strong case for aggression. So my vote is with the charter and with an absolute prohibition on it. And of course, when states, not the permanent members of the Security Council, but other states have generally come together, this is what they've agreed upon, as they did in the outcome document in 2005. Although it is striking, and some of the countries that have taken the view that it is permissible to use force unilaterally to prevent genocide after making what they call a good faith effort include states where this would not be expected, from whom we would not expect this: New Zealand and Denmark. And of course, it's not New Zealand and Denmark who are going to do the intervening. I'm puzzled by their position as well. But this is an ongoing debate, and we may get some legal clarity, at least, if the Ukrainian case ever goes to the merits. So I'm going to stop there. I haven't been closely watching the time, but I think I'm probably just about pretty close to what you had expected from me. And again, congratulations, Stefano. I congratulated you several times, but I'll never get tired of doing it. It's a great book.
Thank you.
Many thanks, Professor Schabas. Very interesting indeed. And also it is very, very nice to see the relationship that you have with former supervisee. I'm also a PhD student, and I hope one day to say the very nice things that you say about Stefano, also with regard to work, as soon as I finish. So I don't know if Stefano would like to reply to Professor Schabas, or if you prefer, we can open the floor for comments and questions from the other people that are participating in the webinar, and then you can go back also to Professor Schabas' input while you address potential questions and further comments, as you prefer.
I would leave the floor open to questions. Yes.
Okay.
Thank you.
Perfect. So I shall now open the floor for questions or comments. Let me first see if there is any hand that has been raised or any question that can also be written in the chat if you prefer to use the chat to pose questions or make comments. Okay, so if that's not the case yet, I'm very happy to take advantage of my position as the chair of the event and pick the brains of our distinguished guests to ask them some questions on my own. So the first question that I have, first of all, let me say that I really enjoyed reading the book. I thought it was extremely well written, and also I appreciated how much Stefano delved into the theoretical background of, in particular, the notion of responsibility to protect. There is one aspect that I wanted to highlight and perhaps also to ask you to expand on during this Q&A session. At some point in the book, you make a reference to the contribution that African authors and experts, and in particular, you make a reference to Francis Deng and to Kofi Annan, have brought to the doctrine of R2P. And in particular, you affirm that Deng is actually the one that proposed the idea of sovereignty as responsibility. We all know that, unfortunately, this contribution has been so far greatly overlooked. And so I would ask you, also from a more practical perspective, which are, in your opinion, the efforts that need to be made to engage more African scholars, but also more African governments in what we can describe as the global struggle to prevent and punish mass atrocities or atrocity crimes? That would be my first question, and I think that we can start from that, and then we can keep rolling the ball. Okay.
Yes, this is very interesting. Also the fact that I dealt with the biases existing in the international community, but also in international law scholarship. I am myself biased, and I recognize I must be aware of the existence of a biased point of view, writing from, let's say, the Western world. And also the very concept of the responsibility to protect was really divisive and controversial concerning the impact that it had on the international community. It was the result of a group of people, of scholars and diplomats summoned in Canada, so in the Western world. And so it is mainly described, as Professor Schabas was saying, as the son of humanitarian intervention, because indeed this was the original formulation. But if we see if we look more deeper in what are the origins of the idea, we see, for example, the idea of sovereignty as responsibility that has the very theoretical aim of protecting populations from atrocities perpetrated by states, where states are unable or unwilling to protect the population if they are not directly involved in the mass violence. And we see that, for example, concerning Kofi Annan, there is the fact that he was the Secretary General of the United Nations in a decade where two events that Professor Schabas mentioned earlier, the genocide in Rwanda and the NATO intervention in the Balkans, also with the genocide of Srebrenica, were not prevented or stopped by the international community. So Kofi Annan was the one posing the dilemma, which has no answer. What shall we do if the prohibition on the use of force admits no exception, but at the same time we cannot avoid doing something when events of mass violence are taking place? So the responsibility to protect, and on a certain degree also the International Criminal Court have been a response to that, an effort to respond to that question. I think that in theory they have contributed to give a response, but we see that in practice they were a failure. The interesting point about the opportunity for what it is sometimes called the global south to join the conversation, at least to have their voice heard in these issues, so to avoid that Western powers and Western scholars just manipulate international law for Western interests. An opportunity was created by the responsibility to protect, because by introducing the question whether or not an exception to the prohibition of the use of force based on humanitarian claims was accepted, they had the possibility within, for example, the General Assembly of the United Nations to say no, to confirm the consistent view of the consistent opinio juris of the international community, of the majority of the international community, that these exceptions are not admissible. There is one state in the world still claiming for humanitarian intervention, which is the United Kingdom, which was just mentioned, but the overwhelming majority of states do not accept such an exception. And yes, hopefully, but also it is likely that the International Court of Justice will affirm it again, let's say, after Corfu Channel, after Nicaragua, after previous cases where it affirmed the purport also of the prohibition of the use of force. There will be another opportunity to reiterate that any action aimed at preventing or stopping mass violence or international crimes or atrocity crimes must be in line with the provisions of the UN Charter.
Thank you, Stefano. I don't know if Professor Schabas would like to add anything on that. Okay, so another point that was raised not only in the book but also now in the discussion has to do, of course, with the big pink elephant in the room, the impasse of the UN Security Council. You have mentioned in the book that there have been some attempts to actually overcome this impasse, and you made reference to the Uniting for Peace resolution, which is something that my students ask me about whenever we talk about the use of force, in the hope that maybe the General Assembly will be able to reiterate something like that in relation to other cases. You have already expressed your skepticism with regard to the possibility of the UN General Assembly to actually overcome alone this incapability by the UN Security Council to take actions due to the fact that permanent members exercise their veto power whenever they feel that their political interest is at stake. And Professor Schabas also made reference to the fact that it seems nowadays that there are other venues that seems more likely, and also judicial venues like the ICJ that he was referring to with reference to the provisional measures that were issued last year in response to the Ukrainian submission. So if I have to pick your brains on the issue of what to do in cases when it seems like the UN Security Council is really not able to step up and intervene to make a pause to atrocity crimes or to prevent in a more effective way the prosecution of atrocities, which are the possible avenues? Like, shall we insist on the potential role of the ICJ? Shall we insist on the adoption of sanctions by regional organizations like the European Union, like they have done since the inception of the war between Russia and Ukraine? Shall we hope that the UN General Assembly will be able to actually vote for the establishment of subsidiary bodies like the IIIM mechanism in relation to Syria? What is the hope that we have to make sure that the international community actually does something about situations that seem to be impossible to resolve due to the lack of political will mainly?
Shall I reply or shall I give the floor to Professor Schabas?
Whatever you prefer.
I can reply, but I don't have an answer. So I would be interested in what Professor Schabas would have to say. Then I can give my view.
I don't know that there is an answer. I mean, the idea that unilateral action is prohibited means that we have to turn towards the organization, obviously the United Nations, but regional organizations, wouldn't be excluded from this discussion, that are able to take appropriate action. And where they can do that, I mean, the General Assembly, its powers are defined by the Charter, and they're not changed really by the Uniting for Peace resolution. They enable the General Assembly to deal with and to address some of the issues, but it's not as if some people think that the General Assembly steps in and has the powers of the Security Council under Uniting for Peace, and that's obviously not the case. I've been very struck by how the other bodies, and in particular the Human Rights Council, appear to think they have a kind of Uniting for Peace mandate as well. Quite surprisingly, the Human Rights Council adopted a resolution condemning aggression in Ukraine just about a year ago. An indication, by the way, that the use ad bellum has its own place within the field of human rights, something that has been contested, including by leading international NGOs who were, if not opposed, certainly indifferent to the codification of the crime of aggression in the Rome Statute. So, you know, when the Human Rights Council adopts a resolution like that and talking about aggression, it's an important development. And, you know, you can go back to 2003. I did the other day just to check on the resolution that was adopted about the invasion in Iraq by the United States and the United Kingdom. It didn't talk about aggression. In fact, it began by condemning the human rights violations of the government of Iraq. That's what the resolution did when the whole world was outraged at the use of force by the two permanent members of the Security Council, without authorization, of course. So this is the dilemma, and I referred to it in my remarks. What can you do? And I think there are limits on unilateral action, and there have to be, because it's too dangerous for world peace, which is also we can't jeopardize that. We can't allow it to be threatened, and we see the example with Ukraine to the extent that Russia has used this. You know, the American narrative always was the narrative of the United States was that, you know, trust us, we'll know what to do. You know, who would ever trust them? The United States, a more self-interested state. All they want to do is maintain their domination, basically, of the whole planet, and they will lie to do it when it's appropriate, as they did in 2003 to justify to attempt to justify the invasion in Iraq. But and we see this echoed in the statements to which I referred, where states talk about a good faith attempt. Well, who's going to make the good faith attempt? Who would we trust to do that? And we obviously don't trust Russia to do it, but nor do we trust. I wouldn't trust any of the permanent members of the Security Council. There are some countries I would trust to make such a determination, but they're not the scary ones. I mean, I would trust San Marino to make a fair determination, and Monaco and Liechtenstein maybe, and Andorra, you know. But once we get beyond that, I'm not so sure. So all of this is to say, I don't know that there's an answer, but we are seeing the willingness of other parts of the system, like the Human Rights Council, to venture into the field of aggression, whether it's defined as a crime or simply a violation of the Charter. And maybe we'll see more of that as well on the regional level. Stefano spoke a few minutes ago about African scholars, but really maybe the body to deal with genocide on the African continent is the African Union. And they've had their own tussles with the International Criminal Court, because the International Criminal Court, the first prosecutor at any rate, showed himself to be deaf to the entreaties of the African Union when it was trying to resolve an important problem of peace and security in Africa, the Sudan crisis back in 2008, 2009. Those are just a few thoughts. I don't have an organized, coherent answer to the existential question that you asked.
Thank you so much. I appreciate it. Stefano, do you want to
respond to the existential question, of course.
Yeah, to the existential question, obviously.
So, yes, the dilemma was posed by, as I was saying, by Kofi Annan, who asked, and I quote, "If humanitarian intervention is indeed an unacceptable assault on sovereignty, how should we respond to Rwanda, to Srebrenica, to gross and systematic violations of human rights that affected every precept of our common humanity?" It is indeed a fascinating question, because it shocks the conscience of international lawyers, who have the responsibility of saying, shall we authorize like the use of force in case of mass violence? But I would stop a bit earlier, like before saying that it is that an exception doesn't exist and that this is confirmed by the development of the responsibility to protect. But such an exception isn't desirable. And the question should be posed, first of all, not to international lawyers, but to the military sector. For example, asking them, would you be able to give an effective answer, an effective response to that? Would you be able to organize an intervention that effectively stops the violence without creating a civil war, for example? Because so far, there have been plenty of military interventions, both within the UN Charter and outside the UN Charter. If we take Libya, for example, or then the Balkans in the 90s, and in both cases there were not appropriate responses. So even the military sector isn't able to give an effective response to that. I think that from a legal and ethical point of view, it's a sort of like of the ticking bomb scenario when we speak of the prohibition of torture. So it's a case that doesn't exist in reality. So it's a way to try to challenge the very tenet of the rule of law and of international law. So what would you do if you had a terrorist that with a ticking bomb that is threatening an entire school or supermarket? Would you use torture to obtain the information that would save people? And also reading the scholarship of philosophers who try to respond to this existential question, is that such an exception from a legal point of view should be wrong. Then ethically, the individual can decide to violate the law, and that individual will face his or her responsibilities for having violated the law. If the individual act is successful in protecting population, in saving people by violating international law, I think that it would also contribute to a reform of international law. But so far, all efforts, all military interventions have proven to be ineffective. And if we see Libya or the limited military interventions that took place in Syria, also from a political and military point of view, were not effective. So I would challenge the dilemma since the beginning, as it has this presumption, this premise that a military intervention would solve the problem, would actually prevent and stop mass violence, but this is not the case.
If I could just join in on Stefano's observation, it's always been part of the discussion about responsibility to protect that the narrative very quickly became militarized. That the whole idea of the responsibility to protect was often presented as being simply, can you intervene militarily or not? And I remember listening to Gareth Evans, who was one of the members of the commission back in 2001 that developed the doctrine and was a big proponent of R2P. But Evans pointed out, he says it's not about sending the Marines. It's not about military intervention. And I think it's been harmed, the doctrine of R2P over the last 2 decades now, by this idea that it's linked to military intervention. There's a famous, a great poet of Ireland, Brendan Behan. Some of you may have seen things he's written in some of his poems, and he once said that there's no amount of human misery that can't be made worse by the presence of a policeman. And I think if we transpose that idea to the international environment, we realize, as Stefano pointed out, that these interventions generally have made matters worse when they've taken place. They've destroyed countries rather than healed them. They've damaged them sometimes irreparably. And we look at the situations in Libya and in Iraq, and where there might be some, and maybe even in the Balkans, where we've seen the tragedies and where the military intervention doesn't solve the problem, and it just in fact contributes to it. I think that, really the issue perhaps is that we need an organization that the world would trust and a mechanism that the world would trust, and we don't have that. To an extent, we would trust the General Assembly, but it doesn't have those powers. And by the way, the 5 permanent members are not going to, they don't love the General Assembly either, because it's controlled by the smaller states and the states of the global south, and can be. And so they'll never accept that part of it. It wasn't so much the case back in 1946 when the United Nations became operational. But this is the other problem, and the beauty of the Security Council that everybody except the P5 hate is that the Security Council, we trust the Security Council because we know that that the five have to agree. It's the veto that means that we trust it not to do anything that's too biased or distorted or that shows that it's in the pocket of one institution, of one group of states or another, and that's kind of the beauty of the veto. But it leads us to these impasses as well. We can see it. I'm very concerned. I mean, we're talking also about the International Criminal Court, where the International Criminal Court has become extremely active and focused on the situation in Ukraine, and this has made it has resolved its problems of financing. European governments are queuing up to give money to the ICC when 2 years ago, when it was worrying about the United States and Afghanistan and about the situation in Palestine, and it was being starved by the wealthy countries, essentially the European countries, who have the money, who provide the money for the ICC, and they were reluctant to give any more money. That's completely changed because the ICC has become focused on Ukraine. But and that's made it, of course, highly appreciated in certain political circles in Europe, but not in the rest of the world. Not in the rest of the world, and I think it's done harm to it. One of the things that I loved about the ICC when it was being created was the idea that it was cut loose from the Security Council. The original drafters, including the International Law Commission, wanted the ICC to be essentially a permanent version of the International Criminal Tribunal for the former Yugoslavia that would be controlled in terms of its focus, in terms of the situation and cases that it would pursue. And that was one of the great achievements, in a way, of the International Criminal Court, of the Rome Statute, was separating the court partially, not entirely, but separating it from the Security Council. The problem was there was no institutional solution other than the Security Council. There was no alternative except the independent prosecutor, who is, the most, has this extraordinary power to determine the focus of an organization with a budget that exceeds 150 million euro a year, and to take initiatives that are highly politicized without having to account to anybody, without having to have a vote of anybody. And this is, to me, this is the flaw in the Rome Statute, is that we don't have an alternative. We don't have an alternative for the court, which really requires for those determinations some sort of democratic collective body that's representative of all of the peoples of the world. If it had that, the ICC would not be as obsessed with Ukraine as it is today. That's for sure. If the office of the prosecutor and the activities of the prosecutor were subject to some kind of oversight by a body that was representative of the peoples of the world, the states parties to the Rome Statute, the South as well as the North, it would be behaving differently than it is today. It would be back working on the Palestine situation, which it seems to have completely abandoned for the last year in favor of working on Ukraine. So I guess what I'm saying is that, yeah, organizations that would have the power to intervene and to address grave, serious human rights violations in third states, they'll only be acceptable if we trust them. And the only body, and it seems odd to say it, that we trust the Security Council because we know it can't be manipulated by one country or another. I'm told, that in the Quai d'Orsay in Paris, they refer to the P3. There's some references to the P3 in the literature, and that in Whitehall, in the Foreign, Commonwealth and Development Ministry in the United Kingdom, they refer to the P2. And of course, there's one country where they refer to the P1, and you know what that is.
Many thanks, Professor Schabas and Stefano as well. I don't know if we have questions or comments from the audience. Otherwise, I will keep abusing my privileges because you have mentioned two words that have actually triggered more questions in my mind. The first one is the militarization of R2P. And I wanted to ask you, since you have highlighted how much actually R2P is now matched with this idea of military intervention, but the original idea was actually to enlarge the scope of responsibility to protect and cover also prevention measures and subsequent capacity building, reconstruction, and reconciliation in the aftermath of mass atrocities. These two aspects seem to have been completely overlooked, with the focus standing only on the actual intervention, actually military operations. So I wanted to ask Stefano, in your book you were drawing a comparison between the ICC and R2P in respect to the things that they have in common in particular. And it seems to me that the ICC also have to some extent at least, these forward-looking mandate, especially since the reparation mandate of the ICC has been so much incentivized and galvanized over the past years, ever since the first judgment has been issued in the Lubanga case. So, to make my question short, these aspect of the R2P that has to do with capacity building, reconciliation, and everything that happens after the atrocities have been committed, and this leg of the ICC mandate that has to do with reparations for the victims and providing redress in the aftermath of international crimes. Do you think that at some point should be or could be put under the same microscope and analyzed from a broader perspective of also transitional justice mechanism that can be implemented under, on the one hand, the ICC mandate and the R2P doctrine?
Yes, thank you. It is a beautiful question, and you already, in asking the question, you already made a very interesting point of, yes, on the one hand, the responsibility to protect obtained a lot of attention in scholarship and in the public debate concerning the so-called third pillar, so the use of force. But in practice, meaning in the practice of the Security Council, it is used, it is mentioned only as a jargon for interventions that do not resort to the use of force. So preventing measures, humanitarian, focus on humanitarian issues, and this is the reality of the responsibility to protect. Also, Judge Bennouna saying that the responsibility to protect died after 2011, he clearly refers to this interpretation that is the most evident one in the public debate. But if we look at the quantity of Security Council resolutions mentioning the responsibility to protect, they kept increasing after 2011, but never referring to the use of force. So it had a different development, which is completely disconnected from militarization. Concerning the International Criminal Court, it is fascinating to think that it could develop a form of justice which is not necessarily linked to the punishment of those most responsible, but, for example, embracing a sort of a number of values that are key to restorative justice, for example, like a focus on the victims and on reparations, on material reparations and immaterial reparations. What can I say? It's true that there are the most effective work of the ICC probably is the most invisible one. There are cases like Colombia where the court started a dynamic with local institutions, supporting local institutions to develop a criminal code, to develop strong tribunals, and to support the the justice process, let's say, in the domestic system. So this is possibly the field, the area where the ICC obtained the best results. Of course, the visibility is somewhere else. If the court disregards the situation in Afghanistan, claiming the interests of justice, or if the court issues an arrest warrant against Vladimir Putin, it obviously catches the attention of the world because it behaves like a court that takes strong political decisions. And for example, in the case of the sitting president, the sitting head of state of the Russian Federation, it aims to behave like a proper criminal court, like having the aim of punishing the perpetrator rather than adopting a restorative justice approach. Yes, I agree with you insofar as the ICC, but not only the ICC, also observers and the scholars and the public debate could also focus on less visible aspects, like the promotion and the support to domestic judicial systems that the ICC promoted in several other situations that we never talked about, in contrast with Afghanistan or Ukraine.
Thank you, Stefano. Okay, one last question and then I'll stop, I promise. Complementarity and the case of Ukraine. You said in your book and also in the presentation that complementarity is actually what makes the ICC standing out from all the other previous criminal tribunals on the international plane. And the complementarity represents the alliance between the ICC and the principle of sovereignty. In the case of Ukraine, we are talking about jurisdiction that is exercised by the International Criminal Court in relation to crimes committed on the territory of a state that is not party to the ICC. And there is this very weird situation in which the referral has been made in support for the prosecutor to start action in relation to the crimes committed into the Ukrainian territory by 43 state parties that are actually members of the Rome Statute. So to pick both of your brains on the issue, can we still talk about effective complementarity on the side of the ICC, or do you think that actually actions like the one, the investigation in Ukraine, have the risk of demolishing the importance of complementarity as one of the central pillars for the functioning of the court?
I give the floor to Professor Schabas.
Okay, you know, the complementarity, of course, is in the Rome Statute as a safeguard for states to reassure them that they would not, that the court would not be unnecessarily intrusive in their own domestic affairs. And it has built into it also mechanisms for states to try to enforce complementarity, like the procedure under Article 18, which is now for the first time since the start of the court, really, we have litigation going on under Article 18. This is the mechanism whereby a state at the stage even before arrest warrants have been issued can ask the court to make a ruling that actually the prosecutor should stop and that there should be no investigation, even when the investigation has been triggered by a state party or by the prosecutor acting proprio motu. And so we have this underway now in the situations that we have appeals in Afghanistan and the Philippines, and we have it at the pretrial chamber in the case of Venezuela. So that law is being made and being developed as we speak, but it is very much a part of the complementarity notion to see how vigilant the pretrial chamber will be, or the appeals chamber, in the case of the appeals, in protecting states, and the consequences, if it leaks out, if it becomes apparent that the court is going to actually be fairly deferential to the prosecutor, and that the prosecutor can very easily overcome the objections of a state based on the argument that the state is actually willing and able to prosecute. It may impact on, for example, future ratifications of the statute, where we now have 123 states parties, but there aren't any new ones, and I don't know, there might be one or two that are thinking about it, but it has very much stalled the whole process of ratification. And so if on the other hand, there's a firm message that if a state is trying to do the job, that the court will leave it alone, then maybe that will reassure some states who are concerned. Now, the Ukrainian case is a very interesting one, because the prosecutor at the end of February issued a statement saying that he believed that he should investigate in Ukraine. He'd made that decision very quickly following the invasion, rather than making an assessment of whether the Ukrainian justice system was willing or able to prosecute. These are the terms in Article 17 of the statute. And then he said that he would have to go to the pretrial chamber, but it would be more efficient if he was to get states to make the referrals so that he could begin the investigations immediately. So this is what he did, but his explanation was not thorough enough, because the other thing that it saved him doing, it wasn't just a matter of expediting the investigation, but if the states had not made the referrals under Article 14, he would have been required to go before the pretrial chamber and convince the pretrial chamber, according to the standards of the Rome Statute, the evidentiary requirements and standards, that Ukraine was deficient and was not willing or able to prosecute such cases. I think it would have been very difficult for him to do that. I would not have been convinced. I've been spending a lot of my energy in the last year trying to help Ukraine's justice system deal with the prosecutions of war crimes committed on the territory of Ukraine. It's not a perfect justice system, but there are many that are worse. A lot of justice systems have their own problems, and this is a justice system that also is subject to the oversight of the European Court of Human Rights. So, lots of good reasons to say, let's just help Ukraine do the job, rather than have the International Criminal Court intervene. And it would have been, to say the least, curious to see what the pretrial chamber would have done with an application by the prosecutor on the issue of whether Ukraine was willing or able to whether such a situation and potential cases would be admissible. Now, we know that the chambers have adopted a kind of a doctrine and interpretation of Article 17 that allows states to consent to the intervention of the court, and maybe that would have solved it. Maybe Ukraine would have appeared before the court and said to the judges, that's okay, we don't have any issue with complementarity. But that's what the statute requires, and although the judges don't have to invoke the issue of admissibility, unlike issues of jurisdiction, if the parties consent to the jurisdiction and don't raise the issue of admissibility, the court is not required to intervene, even though a situation might appear to be inadmissible. But when the prosecutor seeks the authorization of the court to open an investigation, the court must assess that on the basis of Article 17. And I don't see how that could have succeeded, frankly. So we can all wonder whether this is the other thing about this huge distortion, in my view, of the priorities of the International Criminal Court directed at Ukraine. The energy and the resources and the money should be going into the Ukrainian system to help the Ukrainians deal with it. They've already had some trials. And by the way, if you were interested in which system is more efficient, I bet the Ukrainian system will do the job more efficiently and faster than the ICC based on its record. And Stefano, if I may, just a wee and a very humble correction. In your introductory remarks, you referred to the ICC having only convicted 10 people. And that's technically correct. It's what they say on the website, but they don't remind everybody that 5 of the 10 people have been convicted for offenses against the administration of justice, which are not the most serious crimes of concern to the international community as a whole. These are minor offenses that ought to be dealt with by national justice systems, and lead to insignificant sentences as well, even though the judges seem to have enjoyed devoting a huge amount of judicial energy and resources to ruling on whether somebody had abused a witness or something. So all of that to say, no, the ICC website and the public relations people who prepare it are masters at distorting the reality. It's not 10, it's 5. And when they talk about the cases that have been, they say compared to, I think 3 or 4 acquittals, they boast about that. But the acquittals conceals the fact that a number of cases have been rejected at the confirmation hearing stage, and other cases have been dropped by the prosecutor without having a ruling on whether on guilt or innocence. And so there are a lot of failed cases by the judges. So all this to say that it's even less efficient than you give it credit for, which was not much.
Okay. If I can give a positive note about not the International Criminal Court, but possibly international justice in general, it's something I tried also to express during my research, that there are in practice these failures also concerning an unsatisfactory implementation of the principle of complementarity, for example. But it is interesting to observe how the Rome Statute somehow contributed to the development of international justice by also on a cultural level. First of all, from a legal point of view, by creating an international treaty with the definition of crimes and with several aspects that contribute to the evolution of the law from a legal point of view, but also from a cultural point of view. We are experiencing what has been defined as justice cascade, which results in the creation of justice mechanisms that go beyond the International Criminal Court. For example, the Gambia, where there are mechanisms also inspired by what Professor Capone was mentioning earlier, for example, the reparations to victims, which would be an appropriate focus of justice mechanisms. But also concerning Ukraine, there is a wide debate on which is the most efficient mechanisms to deal with aggression, or generally speaking, to bring justice to the violence in Ukraine. And this, from a cultural point of view, is objectively a positive development in the field of international justice, because justice now is something that cannot be avoided to be taken into account in any transitional process. And this is not something to be taken for granted, because 30 years ago it was not like that. And the ICC, maybe also by failing in its mandate, is producing other more appropriate, but other better international mechanisms that deal with the necessity of justice for the victims, which is not necessarily criminal justice.
Thank you. So thank you also for allowing us to conclude on this more positive note, although I must say that I share the comments made by Professor Schabas in relation to the ICC handling of the situation in Ukraine, and perhaps also the misallocation of resources and times that could have been devoted to deal with other pressing issues. And in particular, he mentioned the crimes committed in the occupied Palestinian territories that have been neglected ever since March 2021. So I would say that if we don't have questions or comments from our public, we can perhaps conclude this session. And I honestly thank you for bearing with me and all my questions. I hope that I haven't been particularly annoying, but it was really a pleasure to have the opportunity to have a chat with the both of you. And congratulations again, Stefano, for your amazing book. I was very happy to read it, and I will pass it on to my students as well, because I think that it is a very interesting and very in-depth analysis, the one that you have conducted under the supervision of perhaps one of the most authoritative scholars that we have in Europe and beyond, Professor William Schabas. So thank you once again for being with us. I see that Professor Martinico has joined us, so I don't know if Giuseppe would like to say goodbye as well before we conclude the session officially.
Just to say thanks indeed. I mean, thanks indeed. It has been a very fascinating webinar, so thanks so much.
Thank you once again, Pai, and I hope to see you also in person soon. You are absolutely invited to join us in Pisa whenever you want. Okay, pending invitation.
Thank you. Bye-bye.
Thank you.
Thank you so much. Bye. Have a good weekend. Bye-bye. Thank you.
Thanks a lot.